Okay, we back to this case. Now we have going to the second part, which is whether the Costco can raise the defense of descriptive use. I need use this. Okay. So now we go to the Costco's fair use defense. The code said to avoid liability for infringement, Costco need not rely on a jury to reject Tiffany claim like Costco action created a likelihood of confusion. Costco is also entitled to present its fair use affirmative defense at trial. The Layman Act provided that when a party uses the word constitute a registered mark in a purely descriptive sense, this use may qualify as a permissive fair use. Currently, a defendant may raise a fair use defense even where the challenged material is likely to cause some confusion. Even their activity is likely to cause some confusion, they can raise a fair use defense. To demonstrate fair use, a defendant must establish that it used the alleged infringed term other than as a mark. It means that it used the term other than as mark because which means it used this term in another intention, not use the term as a mark, and use the term in a descriptive sense, and third in good faith. And this discriminative use is provided in 15 U.S.C. section 1115b4. I have opened this paragraph. Sorry, wait a minute. This is a section of the U.S. Federal Trademark Act, the 50 U.S.A. section 1115. This section is about the defense. There are 8 different defense in the U.S. Federal Trademark Act, and the descriptive defense is under the 4 section 1115b4. We can say here the use of the name, term, or device charged to be an infringement. The use is a use otherwise than as a mark, which means they use it, not use it as a mark, but use it to of the party's individual name is in his own business, or of the individual name of anyone in privity with such party, or of a term or device which is descriptive of and used fairly and in good faith only to describe the goods or service of such party. That's the source of the descriptive use in the United States law. So the judges put forth three elements. Now they will determine like whether this case fit with these 3 elements one by one. The first is whether the use this term as a mark or not. If a defendant uses a term as a mark, if a defendant uses a term as a mark, which means the defendant uses it as a symbol to attract public attention or to identify and distinguish good or service and to indicate their source. Okay, if it uses the term as a trademark, then they can raise the defense, the descriptive use defense. But whether a defendant has done so may entail an investigation into whether the challenged material appeared on the product itself, on its package, or in any other advertising or promotional material related to the product, and the degree to which defendants were trying to create through repetition an association between themselves and the mark. The code said a jury could reasonably conclude that Costco did not use the term Tiffany as a trademark. The code said the jury could conclude that Costco did not use the term Tiffany as a trademark, because Tiffany's own evidence indicated that Costco typically identify the trademark associated with its branded product as the first word on the product label. It means we can see the picture. The code said if the Costco want to use a trademark to refer to this product, they will put the Tiffany at the first, not in the middle here. So he say the Tiffany on evidence is if Tiffany typically identify the trademark associated with its branded product as the first word, but in this case, the Costco not put the Tiffany in the first word, maybe the second word or third word. For this indication, Costco produced hundreds of examples of signs for its engagement ring, none of which begin with the word Tiffany or any other brand name. Instead, Costco's evidence demonstrated that it displayed the word Tiffany in the exact same manner like it displayed stating information for other engagement ring. So, and the Costco also proffered evidence that the word Tiffany did not appear on any of its ring or ring payback. It means when Costco when you buy the ring, diamond ring, the Costco will package it, but the Costco did not use the Tiffany on the package, and that the ring actually brought the logo of a different manufacturer. Different manufacturer, the manufacturer are unbranded, and the unfamous, unbranded, but the manufacturer there are cooperation with the manufacturer and the Costco. So the Costco said they not use the Tiffany on the package, and the ring actually bore the logo of a different manufacturer. So this is the first element that the Costco did not use the Tiffany as a mark. And the second element is whether the Costco used the Tiffany as a descriptive use. The code says whether a phrase is a descriptive referred to its tendency to describe the good in question in a broad sense, include not only words like describe a characteristic of the good, such as size or quality, but also words or image like more abstractly identify some information about the good in question. Here, the code says a jury could reasonably find, like Costco used the term Tiffany descriptively. So the code saying the jury could find, like Costco used the term descriptively. Based on Costco's evidence, like 1, Tiffany has a descriptive meaning independent of Tiffany's brand. 2, Costco intended to and did invoke like meaning when it created its point of sale sign. As noted above, Costco has identified over a century's worth of documents suggest like Tiffany, the word Tiffany, both alone and in conjunction with the word like ring, citing style or mounting, is widely understood to refer to a particular type of plunged diamond setting. Costco have proffered many documents suggestion like Tiffany is a style of diamond plunged diamond setting. And as Costco's employees attested in their declaration, both they and their vendors understood the term to be the only precise way to describe a lifestyle. It's a style, not a brand name. Costco also presented unrebutted evidence that it used the term Tiffany exclusively on sign identifying rings bearing a Tiffany setting, and that it displayed the same set of information for engagement rings of all styles. In other words, Costco would generally display a diamond ring with a cathedral or bezel diamond setting. Is interested cathedral or bezel diamond setting, along with a sign display the word cathedral or bezel in the same way like sign identify a diamond ring with a Tiffany setting. So the Tiffany used here is as a diamond style, such as cathedral style or bezel style, a Tiffany style. But the Tiffany company resists like conclusion like the term Tiffany is amenable to descriptive use, or Tiffany resists this conclusion. It argued that no case has ever bisected, I'm not sure how to pronounce it.
Bisected a trademark to allow the same word to be used exclusively by the trade.
Bisected. Okay. Have ever bisected here. Bisected. No case has ever bisected a trademark to allow the same denote the source of good for every product in a registered class except one. And like doing so here would bring about the absurd result, like Tiffany could be a source identifier for rings of other styles, but a descriptive term for rings in the so-called Tiffany style. Okay, but the code said Tiffany argument fundamental misunderstood our case law. There is nothing inherently absurd about a single word being both a source identifier and a descriptive term within the same product case. Okay, the code here raised some precedent, the case, old case, to show to Tiffany like there has ever the case very similar with this case, such as the Abercrombie case. The same term may be put to different use with respect to a single product. To the extent like Tiffany actually does have the descriptive meaning, Costco submit like it does. Tiffany's putative absurd result is nothing more than the predictable reality of a legal region in which trademark right may be acquired in a word or image with descriptive quality, right? As we have told, like the whether a word or term has distinctiveness, maybe some word the descriptive trademark, which the distinctiveness is less, is few, but they still can be registered as a trademark. So here the code explains like Tiffany can be a brand, can be a trademark, but Tiffany could also be a descriptive terms. And within that reality, it is well established like the public right to use descriptive word or image in good faith in their ordinary descriptive sense must prevail over the exclusivity claims of the trademark owner. Okay, so the okay, we have seen the conclusion, like the second code think the Costco's use is this descriptive use because it fit all three elements here, not use it as a trademark. Its use is this descriptive use and it's from a good faith. So the second code think the Costco use the term Tiffany is a descriptive use. Okay, we finish this case. We back to the PowerPoint slide. Now I have said that sometimes it's difficult to distinguish these two fair use. It's difficult to distinguish the descriptive fair use and the nominative fair use. So there is a famous case in Taiwan, which is revised to a lawyer examination question 2021. We see here in this question, Party A applied to register the trademark Integrative Beauty, designated for use in distribution service of various skincare products, among other beauty-related service, during the opening period of its physical store. In order to attract crowded, Party A purchased several sets of brand Chanel skincare kits that are already registered domestically in country Z, maybe in US or Europe for use as a prize in a lucky draw. Lucky draw. Lucky draw. So in this case, a party A has its own trademark, integrative beauty. But the party A purchased several sets of brand Chanel. The party A purchased the Chanel product to use as a prize in a lucky draw. Then party A distributed promotional material during the opening period to advertise the product for sale, stating on the flyers, spending over 5,000 NT dollars to participate in the lucky draw. Lucky draw. With the grand prize being a Chanel skincare kit worth 20,000 NT dollars. Additionally, party A hung banners printed with "Win a Chanel skincare kit" slogans. Okay, I said it's a real case, famous case in Taiwan. That's the case. The party A is here, Poya. And the Poya want to celebrate this 30 years as anniversary. They buy several Chanel product to hold the lucky draw activity. The winner will get the Chanel product, a Chanel bag. But in this advertisement, the Poya is very small. Use the small words in the post. But the Chanel is very big. You can see here, Poya is small and Chanel is big. And the Chanel trademark is big. So even in this post, Poya, the word Poya, Chanel, almost the same, but this sign is also the trademark of the Chanel. It's bigger than the Poya. So the question is, the first question is about another topic, like whether the IPO, whether or not the IPO approve the trademark registration application for integrative beauty. Why this is question? Because the integrative beauty has no or not much distinctiveness. Because the integrative beauty is maybe we can say it's a general word in the beauty related service, or the descriptive word among the beauty related services. So maybe it will lack of distinctiveness. That's the first question, but we in this case we are not focused on this first question. We focus on the second question. The second question is the authorized agent of brand N in Taiwan. Party B. Sorry, I used here party A. Sorry, maybe the brand should change it to the Chanel. The brand Chanel. The authorized agent of brand Chanel in Taiwan, Party B, claimed that Party A's advertising activity were conducted without Party B's consent, thus infringe upon brand A's trademark right. brand Chanel's right. Party B demanded that Party A immediately withdraw the promotional material and the banners and refrain from sending out such promotional material again. The question is, Party B's claims reasonable? Okay, that's the real case. The question is adapted from the real case, the judgment of the Intellectual Property Code in Civil Trademark Lawsuit 2016 and 2017. The 2016 is the first instance. First instance. In Chinese, it means the first trial, and the case of 2017 is the appeal case. Okay, so let's see the judgment. First, the first instance judgment. The judge think this case, they think is not nominative fair use. Nominative fair use, which means it's not a fair use, so it's the defendant Poya had infringed the trademark of Chanel because the code said the Poya cannot raise the normative fair use defense. Okay, we see the reason of the judgment. Below is the paragraph from the judgment. I just put some paragraph here. First, the disputed action here constitute trademark usage, which means the code signed, the first code signed, the Poya used the Chanel and the sign as a trademark use to attract the consumer's attention to promotion. That's the trademark use. The code said the defendant, Poya, being a profit-oriented organization, carried out the disputed action extensively during the contested activities period. These actions were aimed at soliciting customers. Soliciting customers. Soliciting customers, stimulating the willingness of related consumers to consume, increasing the turnover of each branch, and obtaining commercial profit. So they involved the extensive use of the plaintiff trademark for promotional activity, such as offering complimentary gift to promote the sale of goods or service. Therefore, they fall within the scope of trademark usage as defined in Article 5 of the Trademark Act. I wish you remember that we have introduced the Article 5 of the Trademark Act, which defined what kind of activity is the trademark use. And one usage is you use the trademark in the advertisement. So the code said the defendant Poya used the word in this promotional activity, which is fall within the scope of trademark usage as defined in Article 5. And they explain furthermore the dispute action have exceeded the reasonable limit. During the organization of the contest event, the defendant Poya used the disputed trademark design and the product photos. We have seen the product photos. These product photos. Even they find model to bear the bag to take picture. In marketing material. Moreover, the proportion of space occupied by this element exceeded that of phrase such as Poya and Poya 30th anniversary fashion celebration. So the proportion is bigger than the Poya's part. Thus, existing the reasonable scope of informing consumer about the plaintiff product contained within the content of the contest event. This indicates an intention to associate with the dispute trademark. Furthermore, if the defendant merely needed to inform consumer that the contest event would provide the plaintiff's Chanel's product, this could be achieved through textual description alone, effectively conveying the message to relevant consumers without need to use the disputed trademark and the photo. So the code said if you need to tell the consumer that your pride is the Chanel product, you can use only the textual description alone, not to use the trademark to photo. You don't need to use it. Additionally, there would be no requirement for models to wear the plaintiff product for promotional photo shot, resulting in the disputed trademark occupying a significant portion of the marketing materials for the contest event. Therefore, the defendant Poya's strategy of extensively using the disputed trademark in promotional material, coupled with the purchase of a small number of plaintiff Chanel products as giveaways to attract consumers to the contested event, the code said is sufficient to establish the defendant Poya's intention to associate with the disputed trademark. And the second reason is the code said the dispute action are inconsistent with the industrial norm. Okay, I have reminded you that in the paragraph, if you want to fit this nominative fair use, you not only use it as a nominative, but it have to fit the honestly practice in industrial or commercial matter. You must fit commercial practice. So the code said department store here. Department store using brand name luxury trademark for advertising or promotional activity are usually the department store are expected according to the industrial convention or practice in luxury and department store sell to negotiate, discuss, and obtain authorization content with the brand name luxury good manufacturer. The code say is the industrially known or industrial practice. In this case, the plaintiff Chanel disputed trademark is a globally renowned luxury brand, yet the defendant did not obtain consent with the plaintiff to directly use the disputed trademark to produce numerous advertisement and promotional material. The code sync is clearly deviated from the industrial norms. And the third reason, the code says relevant consumers are unable to discern the lack of cooperation or authorization between the plaintiff and the defendant, which means the consumer will confuse. They will they will think like maybe there is cooperation between Poya and Chanel, but actually there is no such cooperation. The code says while the defendant brand primarily focused on selling women's clothing at its inception, its product range now include fashion, handbags, shoes, watch, perfumes, jewelry, cosmetics, skincare products, and other luxury accessories. In recent years, it has also cooperated with domestic luxury department stores, participating in their annual anniversary celebration, demonstrating a move toward diversified cooperation in line with contemporary trend. Therefore, the defendant's use of the disputed trademark design, product photo, and the creation of puzzles feature the plaintiff. The puzzle means the double C. Feature the plaintiff product may lead to relevant consumer to mistakenly believe like the defendant Poya have obtained prior authorization and had a cooperative relationship with the plaintiff Chanel. Moreover, during the contest event, the defendant Poya did not clarify to relevant consumer that the use of the disputed trademark was not authorized by the plaintiff Chanel. So it will make the consumer to confuse like there are some association, some cooperation. So the first instance, the first instance judgment ruling like the defendant could not use the nominative fair use, which means the defendant loses the case in the first instance judgment. But after the defendant appeal to the appellant court, in this the appellant court revoke the first judgment. The appellant court think the Poya's conduct constitute nominative fair use. In this case, they use the word appellant. Appellant is Poya, and the respondent is Chanel. Okay, and the appellant code say the requirement for constitute nominative fair use are as follow: 3 elements. First, represent a description of the good or service in a manner consistent with honestly business practice in the trademark trade. Second, represent one's own name, title, or the name, shape, quality, nature, characteristic, use, place of origin, or other description related to the good or service then sell, but in this case not related to this second element. Third, not being used as a trademark user. The code said first, relevant consumer recognize that the respondent. Respondent. I check like, oh, sorry, I make a mistake. In this case, respondent is Poya, and the appellant is Chanel. Okay, the code think the relevant consumer could recognize that the respondent Poya's lifestyle store is hosting the contest event. When considering the appearance of the disputed trademark in the contest event, it is necessary to observe the overall behavior of the event and not rely solely on the layout of individual sign or promotional material to interpret the scope of trademark usage. Considering the usual course of transaction when relevant consumer perceive that the respondent Poya's lifestyle store is hosting the contest event, they understand that the main entity behind the event is the respondent itself. When visiting the respondent premises, consumers do not typically focus exclusively on advertisement or promotional material, but rather take into account other promotional materials such as Poya Fashion Anniversary Celebration or Poya 30th Anniversary Fashion Celebration, and not just the text such as Chanel or in Chinese 香奈儿. Therefore, when the respondent Poya display the disputed trademark during the contested event, it is not for the purpose of promoting its own goods. The display of the disputed trademark during the contested event does not serve to make relevant consumer recognize it as a trademark. It says relevant consumer did not recognize it as a trademark. Instead, its purpose is to inform consumer about the draw for contested giveaway during the event. Consumer understood that the contested giveaway originated from the respondent, so there is no risk of confusion. Furthermore, when the respondent sells its own goods, there is no likelihood of confusion or association with the appellant. The code explains more detail. The disputed trademark is used to indicate the source of the contest event giveaway. The concept of using a trademark in accordance with good faith business practice refers to the use of a trademark in a manner consistent with common commercial practice, without any intention to use it as a trademark subjectively. Instead, the trademark is used descriptively or nominatively. In this case, it should be nominatively, but you can see the judge sometimes they use these both words, which means even the judge can distinguish whether it should belong to descriptive use or nominative use. And instead, the trademark is used nominally and objectively. Relevant consumers do not perceive it as being used as a trademark to identify the source of good or service. Referring to the respondent contested activity or behaviors, which included the display of their trademark Poya, it is evident that the contested activity or behaviors included the display of the disputed trademark. However, the display of the disputed trademark Chanel is solely for the purpose of conducting draw for the contested event giveaway, which serves as an explanation of the source of the contested event giveaways themselves. The respondent has no intention to imply or associate with the goodwill of the disputed trademark. Instead, it is merely used to explain the source of the contested giveaway and does not constitute trademark usage, the code said. In other words, the respondent does not use the disputed trademark as a trademark to indicate the source of its own goods. Relevant consumer perceive the source of the appellee's goods as being the POYA trademark rather than the disputed trademark. Therefore, there is no risk of confusion or misunderstood regarding the source of the respondent goods. And the second about the industrial practice or industrial norms in the luxury good industry, the appeal code disagree with the district code. The appeal code thinks while the appellant claims that it is customary in the luxury good industry for department store using brand name luxury trademark for advertising or promotional activity to negotiate, discussion, or obtain authorization from luxury goods manufacturer, the appellant has not provided evidence regarding the relevant actual norms, actual practice, and specific guidelines. Moreover, the respondent POYA is not a participant in the luxury good industry and therefore cannot be expected to be familiar with such norm or such practice. The code thinks, considering like the promotional material of the respondent do not mention sponsorship or joint collaboration by the appellant, similar affiliated enterprise or celebration in conjunction with the appellant brand. Moreover, there is no cooperation relationship between the respondent and the appellant, so there is no need for the respondent to comply with the industrial norm claimed by the appellant. And the third reason, the appeal code said the respondent POYA does not utilize the disputed trademark to indicate the source of good. The respondent conduct the contested event and display its own trademark POYA during the event or activity, enabling relevant consumers to recognize the seller of the good as a respondent itself. The appeal code said in the context of the transaction process, relevant consumers are unlikely to mistake the respondent POYA's marketing intention as using the disputed trademark to identify the source of good. Instead, they perceive the disputed trademark as merely indicating the source of a contest giveaways. Although the contest activity or behaviors may include the display of the disputed trademark, consider their purpose and method, they are only used to provide relevant explanation about the contest giveaways. Therefore, they do not possess the intention of trademark usage and are considered the ordinary use in transaction rather than trademark usage as defined by trademark law. Therefore, objectively speaking, it is recognized that the respondent has acted in accordance with good faith business practice rather than use the disputed trademark to indicate the source of good. According to Article 33, Paragraph 1, Subparagraph 1 of the Trademark Act, which pertains to the good faith use of trademark, the action in question falls outside the scope of the dispute trademark right. Hence, the appellant cannot claim that the respondent have infringed upon the disputed trademark. That's the conclusion of the appeal code. So I finished this case. As we have seen, the appeal code, the conclusion of the appeal code is different from the judgment of district court. So it shows like whether the defendant could raise the nominative fair use. It depends. There is much uncertainty, especially on the special requirement. Like the code will decide like whether if the conduct is in accordance with the honest, good faith practice in industrial or commercial matter. But what is the practice in industrial or commercial matter? We have seen like the appeal court have different opinions with the district court.